Hi, hey, this is Trish Elledge. Thanks for pushing the little button below so that you could listen to this recording. I appreciate it. Listen, I wanted to do this informally like this because I've been getting so many emails and phone calls a lot lately from parties that have been ordered to mediation from like workplace agencies, even the sheriff's office, and obviously courts to enter into a mediation. And they're just like, well, what is this? What are we supposed to do? I don't know what to expect. And oftentimes I find out that even though I've been doing mediations now in over 10,000 cases for 27 years, people still don't know what mediation is. And I have a little document that you can download that if you want to about what mediation is, but this might be a little bit easier. And I know a lot of people do like the video over the words. But in definition, mediation is a confidential process where the parties can come together. Now, sometimes that's in one room, and sometimes the parties are in two separate rooms, and the mediator shuttles back and forth. But the mediator is an impartial third party whose job it is to facilitate the parties' communication and negotiation process. Mediators don't have the power to decide, coerce, or enforce mediated agreements. So it's supposed to be a very human process. Mediation's styles can vary. Some are a little bit more formal, some are very informal. As you can probably tell, I'm kind of an informal kind of gal. So the essence of the process is that it's the human element, it's the human experience based on needs and interests of the parties involved in the disputes. And oftentimes, if parties are on the same page, they wouldn't be in mediation. So obviously, mediation is about conflict resolution if possible. We cannot force or coerce a mediated settlement. So if at any time a party feels coerced into a settlement, it's a red flag for you. All you need to say is, this is not what mediation is. I know it's not, and I don't choose to proceed this way. Just call it like it is. We don't have the power to force or enforce, and call it like it is. It's a safe process. It's confidential. That means everything stays in the mediation setting unless the two parties come to a signed agreement, and I would say at the end of the session, because easily, if you leave a mediation without a signed agreement, typically one person or another can back out. And boy, is that frustrating for the party that didn't back out and thought that they were negotiating in good faith. So a signed mediated agreement, especially if it's a court ordered or a workplace ordered or something, other kind of enforcing agency ordered, it will have some teeth in it. It will be able to be then enforced by that enforcing agency, and your case can be closed. In the event you don't reach agreement, then that dispute then goes to the higher level of the referring agency. So in a workplace, it'd go over to back to HR, and they would take it through the formal grievance or discipline procedure of that company or organization. If it's the sheriff's department, they'll do their thing. And if it's the court, it will go move on to a litigated case, and you'll have a contested hearing. Sometimes mediations end in proposals, and people can continue negotiating after that, and they can come to their own agreement and submit it to the authorities afterwards too. So it helps in any kind of case management that way. The bottom line, if you engage fully in mediation, you'll learn so much more about yourself, you'll learn about your case, and you'll learn about what's happening from the other side's perspective and what their proposals are to determine how far apart you are. There's always the ability to continue negotiation in most mediations. Sometimes people will say absolutely not. After 10 days, this will be off the table. But generally, people like to try to negotiate their outcome if possible. In the event that you cannot reach a full settlement, you will go to the next enforcing agency's prescription for dispute resolution, and that might not feel so good to you. I don't know about you, but I prefer to have the decision-making authority in my hands in as many aspects of my life as possible. So, there is a risk, but I do ask each person that is engaged in a mediation to really say, what can I live with here? What can I live with? What do I need to give them so that I can get what I want? If I give them as much as what they want and they give me as much as what I want, if possible, then we got something to work with if we can both live with it. So that's sort of my 2 cents worth. understand it's a confidential process. Everything stays in that room. The only thing that goes out of that room is the agreement that the two of you reach through the mediation session or otherwise. You cannot go be spewing forth on Facebook or Twitter or the internet about your mediation session. It's confidential. And everybody has a different style. Every mediator's different. Every party's different. And fear works a lot in mysterious and not so mysterious ways. So just be smart. If you're in conflict, weigh the value of staying in conflict and what that does to your life, pocketbook, and psyche. And figure out what maybe you can do to move your dispute resolution discussions to the next level. And by the way, if you would like to sign up for a free 10-minute consultation, just fill out the contact form below and I'll get in touch with you. If you're wanting to schedule a mediation, click into the scheduling instruction link to the side here, and you can get all the information it takes to be able to schedule a mediation with the Eldridge Group Mediation Services. And hopefully we'll see you again soon. And if we don't, hopefully that means you guys settled it. So awesome. Okay, over and out for now.